Walimbwa here would now bring him under this court. It is treason. So we are urging the court, Mr. Chairman, that once we raise the questions as we have done, the honor or the duty of this court is to put the question in proper wording and send them up, and not to determine whether the questions should be sent up, because it has been done already. There has been a request. Mr. Kalibala also referred to the Enforcement Act of Human Rights and said derogate from a non-derogable right, Mr. Chairman, is an offense. That should be section 11, and it's true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin to that of the judge advocate, to advise the court. It is a duty, the old court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So the judge advocate, if it becomes aware that this court is deviating from he's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I would be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from a non-derogable right, because the defense of saying we are executing our mandate of officers established under an act of law will not be available to you distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and given that the same command the force to subject itself to civilian authority, we do request that as commanded by Article 137(5)(b), which directs the court to submit the question, that when my colleagues have raised the questions, we do not engage, and most politely, with questions as to whether we should refer. Rather, we spend the other part of the day by getting the right language of the questions, which shall then be referred to the Constitutional Court to interpret as they are mandated to do under Section 130, Article Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say you, my lord, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which give this court power to interpret provisions of the Constitution or of any other law. We therefore request that we surrender to even which sets in place this court, and the questions be crafted with the aid of our colleagues and ourselves and sent to the higher court for the necessary interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we had about jurisdiction, about impartiality, about extraterritorial effect, which are now the paining points, are handled, and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, and the members of the panel for listening to us. Thank you.
Thank you, Mr. Chairman and honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. You'll permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1, 2, 3 minutes to reinforce the 2 issues, the first 2 issues on Counsel Kalibara raised with authorities only. The arguments have been adequately canvassed, and we are convinced this honorable court is persuaded by those submissions. Now, with authorities on vagueness of section 128, that is issue number 1, the vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamaji. I'll furnish you with a copy with you. Rather, I'll furnish you with a copy. Andrew Karamaji, Robert Shaka versus the Attorney General. It's Constitutional Petition number 5 of 2016. Kindly get me a copy to the judge advocate. But the point emphasized here, Mr. Chairman, the doctrine of vagueness in legislation. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a formal aspect, an acquiescence with the actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether a law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1992 decision which you will find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and the limitation of enforcement discretion viewed in fuller context of analysis and the quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all that. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators like this General Court Martial is so extensive that it would lead to arbitrary prosecutions. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecutions. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. One, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. They refer to the case of Charles Onyango versus the Attorney General. So this authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding on this honorable court. And it's very instructive in that when you look at Section 128, it opens the floodgates. It cuts the net wide offenses relating to security. And punishment, death. This is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the Constitutional Court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offenses compromising security. The other issue, the second issue, again I will cite the authority, the issue relating to subjecting civilians to martial law, which my learned friend here adequately canvassed. But the authority, and he cited a number of authorities. He cited the ones of Uganda Law Society, he cited Amoni Byarugaba, and cited Kabaziguruka and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kabaziguruka. The one of Amoni Byarugaba, which is 2022, and it was very, very clear. And on that one, there was an appeal. The one of Byarugaba. Yes, the Attorney General preferred an appeal against the decision in the Kabaziguruka matter. But the one of Amoni Byarugaba, there is no pending appeal. There is no any order of stay and no any other order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order of stay in the Kabasiguruka case. That has also been succinctly handled by the Constitutional Court, which took a decision in that case. They have decided it. One, in the case of Amoni Byarugaba, but more sufficiently in the case of Semuju Abdul Nur versus the Attorney General, Constitutional Petition number 4 of 2018, the most recent one. It is, to be exact, it is the 3rd February 2023. It is as fresh as these charges before you. This decision, the lead judge, may his soul, Justice Kakuru, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Kabasiguruka case. He summed them up and he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 2, 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Kabasiguruka versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I'll reproduce the declarations in extension for clarity. He highlighted them. I may not take your time, but they are very few. Yes? Yeah, just number 5. No. The General Court Martial established under section this. No, number 2, the General Court Martial's jurisdiction is only limited to trying service offenses under the UPDF Act. Then he said, and 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. No. 5, sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional, as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Kabasiguruka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Kabasiguruka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions which are likely to come from the other side when they are replying. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Kabasiguruka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Kabasiguruka petition apply to this petition. This is as of recent as 2023. So this court, I'm afraid to say, its hands are now tied. It has no choice but to go by the declarations in the Kabasiguruka decision and reinforced in the decision of Semuju and Byarugaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpanga he has raised of Article 3, any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court with all due respect to the General Court Martial, it will be treasonable. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution, Article 3, is very, very clear on observance of the constitutional order, respect to the given constitutional order and the interpretations given. So I urge you, Mr. Chairman, and members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame three issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing, Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to a fair hearing and other relevant provisions? So I don't need to labor so much because we argued out that point earlier on. I would like to adopt the submissions we made earlier on about rendition in violation of the extradition laws. So I would like that matter also to be referred to the Constitutional Court. The other issue, Mr. Chairman, is the jurisdiction of this Honorable Court to deal with cases under the Firearms Act. Mr. Chairman, in this Kabaziguruka case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one of Semuju. So clause 4, paragraph 4 of the decision. No. Paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the preserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Kiiza Besigye, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 119. I'm sorry, it may not be that clear. The photocopying was not clear, Mr. Chairman. That offense, Section 3(1) of the Firearms Act, which is now Section 4 of the Firearms Act, and it canvasses count 3, 4, and 5. that offense does not fall under section 119 of the UPDF Act. The offense of unlawful possession of firearms ordinarily the monopoly of the UPDF forces. They said this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. They went ahead to say that government or UPDF attempted to come up with an instrument number 13 of 2006, ostensibly I think to address that lacuna. Uganda People's Defense Forces arms, ammunitions and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my land friend here was still the judge advocate, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those illegal challenges. In other words, their finding was that you cannot widen the scope of section 119 to bring into operation the provisions of the Firearms Act or any other law, including the Suppression of Terrorism Act, which is a preserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say reincarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly the animal code offenses which are ordinarily a monopoly, no, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the Besigye decision, this animal is still anonymous, undefined. And the attempt to do so in this instrument were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and clearly dissected and explained, this General Court Martial cannot try offenses under the Firearms Act. So we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of counsel Kiiza, one of the defense lawyers, amounts to violation of Article 28.3 of the Constitution. Mr. Chairman, Kiiza, it's on record, up to the present moment, is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Kiiza to execute his duties as per the instructions given to him and as per the record? There was a preponderance of doubt. I read it on your mind. If I read you right, correct, Mr. Chairman. You said, is there a precedent to this? Could it happen that a person convicted can also come here? Then the judge advocate was of a similar doubt. The only forum where that doubt can be cleared is the Constitutional Court. And the Constitutional Court has had occasion, this is the last authority I'm citing, the self-control. In this case, it's one of the locus classicus case on rights, fundamental rights, Article 28. Uganda Law Society and Jackson Karugaba versus the Attorney General. The lead justice, I think, was Mpajiba Higeibi. They gave a purposeful interpretation. Of course, this is the command of the Constitution and rules of interpretation to Article 128. Article 28 rather. Each and every of the above Constitution, each and every of the above rather not of the above constitution. Each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing. Article 45 of the Constitution provides human rights and other freedoms additional to these rights. Mr. Chairman, during the trial here, during the hearing of the prayer we made about the appearance of our colleague, Kiiza, the judge advocate here indicated and said, but you see, Article 28 talks of the right to legal representation. It does not specify the numbers. The answer lies in this decision. That Article 28, which talks about the right to a fair trial, is not even exhaustive when it even talks about those key elements. It's the reason the CA had to insert Article 45. That there are situations that may arise that would warrant one to enjoy more than what you can even see. Why Aaron Kiiza is indeed needed in this case can only be answered by the person who gave him instructions. He knows the reason, and he should be facilitated to prepare his defense. And one cannot say, just especially from the other side, from the judge advocate, that what role is he going to play when the accused person has got over 30 or 40 lawyers. The prerogative rests with him to determine who should be there, who shouldn't be there, and to have a lawyer or lawyers of his choice. That is the language of the Constitution. Aaron Kiiza remains his lawyer of choice for a reason which should not be derogated, because that is a non-derogable right, the right to a fair hearing. Article 28 and 44, it's a non-derogable right. So I reiterate the prayers made. I will not go into other issues. I beg that Mr. Chairman and honorable members that you proceed to do what is commanded by Article 137 to refer this matter to the Constitutional Court. I beg you to move.
Please, Mr. Chairman, I'll be brief because my colleagues have expounded on most matters. But I want to begin by reminding us that in Article 5 of the Constitution, Uganda is declared a republic. And then move on to cite several characteristics of a republic. Characteristics of a republic: there must be, the people must be the source of authority. And that's what the Constitution of Uganda says. Everything is done in the name for and in the name of the people of Uganda. The people must also elect their representatives to make laws and serve their interests. And that happens through parliament. In a republic, there must be rule of law. Law that applies to everyone equally. And this will be very important in an issue that I'm going to raise. In a republic, there is protection of rights. The government protects the rights of citizens. Another feature of a republic is the absence of a monarchy. A monarchy is where leadership is hereditary and to families. There is also equality of rights. All citizens have equal rights. Those are some of the characteristics of a republic. Uganda being a republic and having representative democracy and having a constitution that protects the rights of the people, this court-martial is enjoined to follow the Constitution. So what does the Constitution say on the reference of constitutional questions to the court, to the Constitutional Court? I want to read Article 137, subsection 5, where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than a field court martial, and I want to pause there and say this is not a field court martial. This is a general court martial. So this section applies to this general court martial. The court may, if it is in the opinion that the question involves a substantial question of law, the court shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for the decision in accordance with clause 1. So you can refer the matter of your own accord. But when it is requested by a party, the way now we are requesting you on behalf of these two gentlemen, Dr. Besigye and Mr. Rutale, you have no leeway. You are commanded by the Constitution to refer the matter to a constitutional court. The matter, as my colleagues have canvassed, arose in the course of your ruling, Mr. Chairman. And I will not go to the questions they have already framed. I will go straight away to a different question, the question of freedom from discrimination, in line with Article 21 of the Uganda Constitution. When there is no law to define who in Uganda chooses to bring civilians like Dr. Besigye and Mr. Rutale to the General Court Martial instead of the courts of judicature, that subjects them to discrimination, and it is our prayer that this question be added, whether it is discriminatory to bring civilians to a general court martial instead of a court of judicature, especially without a defined authority that makes that choice. Because the question we are asking, who made the choice? We do not know. The charge sheet does not tell us. There is no gazette notice to tell us that XY is the one who made. We can only guess that authorities within the military decided. But it's an authority we cannot touch. It's an authority we do not know. And in a democracy, discretion and power is limited by the Constitution and laws. There is nothing in this Constitution prescribing how, who and how the decision to bring civilians to a court martial is made. Therefore, when they are brought at the whims of people we do not know, authorities not defined, it becomes discriminatory. We want the court to answer whether indeed this is discriminatory, as we state from the bar. My colleagues have already argued that the fact that the offenses for which they are being tried are not defined is again something the Constitution abhors. And I've already said constitutions exist to limit exercise of power. So if exercise of power is not limited by the Constitution, then it is unconstitutional. And the court, the Constitutional Court, needs to answer that question. I also want to add one more article of the Constitution that Article 79 of this Constitution of Uganda, which mandates Parliament to make laws. It defines the functions of Parliament, and it says that subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Except as provided in this Constitution, no person or body other than Parliament shall have the power to make provisions having the force of law in Uganda, except under authority conferred by an act of Parliament. And then finally, Parliament shall protect this Constitution and promote democratic governance. So the exercise of power to cause civilians to come to a general court-martial are not defined in any law, and therefore they are unconstitutional and against Article 79. And we are asking you, in framing that question, whether we can have exercise of power without, or discretion without limit, is unconstitutional. Add Article 79 to that request. Finally, everybody, including yourselves, is obliged under the Constitution of Uganda to obey it. So we are urging you to stand up for the Constitution and to refer these questions to the Constitutional Court so that we can have finality. It's maybe somebody may argue that because others have taken the questions to the court, to the Constitutional Court, they have already been answered. I want this General Court Martial to note, we have raised questions that have not been raised before. There are some that may be similar to those that have been raised earlier. Questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process. There are various, quite a number of questions that have not been asked before. Also the fact that there is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of Parliament conferring judicial authority on civilians to the General Court Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF. And Mr. Chairman, when you are reading your ruling, you actually found that it was not, you alluded that it was not unconstitutional. The authority to interpret the Constitution is exclusively to the Court of Appeal, sitting as a constitutional court. So it will be useful even to you and the General Court Martial to hear an authoritative interpretation from the Constitutional Court as to whether you indeed can try any civilian in Uganda. The issue of extradition from Kenya, not extrajudicial rendition, not extradition. Extradition connotes a court process where orders are made. In this case, there was no court order. We urge that those issues are more than enough, and I'm asked by my colleagues that since we have exhausted, we end it here to give the prosecutor the chance to make a rejoinder.
Never miss a moment, never miss a story. Stay informed anywhere, anytime with the revamped Nation e-paper. Now you can enjoy access with a superior user experience, improved layout for better navigation, ease of reading, and a more responsive interface on your device of choice. Remember, you can also access archive copies and catch up on news that you may have missed out on. Visit
Nsubulagana waliwo yabadde ava ku kisaawe Entebbe yasiibuddwa mumyuka nga omukyala Jessica Alupo ate n'abakungu ba gavumenti abalala.